Dear students, subscribers and the viewers, welcome to the IAS Mentor. This would be our lecture number 36 in the series Indian Polity. As it has been already stated, the objective of this series is to give a comprehensive idea on the subject Indian Polity. And in the process, we will also cover upon the important books relevant for the UPSC examination. And this series is not only useful for the students preparing for the UPSC examination, but it will be extremely useful for the students preparing for other competitive examination as well, where Indian polity is a subject. So with that, we'll move to the lecture number 36 in the series. And today we are going to start a new theme in the fundamental rights. So far we have covered three important themes in fundamental rights. We have covered right to equality, and then we have covered the right to freedom, and then we also covered right to exploitation in the last class. So now we are moving to the right to freedom of religion, or the religious rights that is guaranteed under Article 25 to Article 28 in the Constitution within the Part 3 of the Constitution. So this lecture I'll deal with Article 25, which I would say is very, very important for you to have an understanding of what is guaranteed under Article 25. And in the next lecture, I'll cover what is governing under Article 26, 27 and 28. So I'll divide this right to freedom of religion into two lectures. So students who are watching this particular lecture, I'll also recommend you to watch the next lecture also, so that you have a complete idea on what is this right to freedom of religion. So with that, we'll just move to today's lecture. We'll try to understand as to what is guaranteed in the Constitution. To have an understanding of that, but first let me give a brief overview as to what is guaranteed in Article 25 to Article 28, which basically provides what is called as a right to freedom of religion. Article 25 of the Constitution provides us the right to conscience and the right to profess, practice and to propagate the religion of our choice. So whereas if you look into Article 25, the very crux of Article 25 is it is guaranteeing every individual in our country to have certain religious rights. So this is more of individualistic in nature. So every individual shall have the right to conscience and to profess, practice and to propagate the religion of their choice. And the very crux of this article is religion is more of an individual choice. Religion is more of a personalized affair. The state has nothing to do with what an individual has to do with his belief in a particular religious matter. That's the overall idea of Article 25. But however, under Article 25, again you will understand that this right or the religious right that is guaranteed under Article 25 is also not an absolute right. It comes with certain restrictions, and of course there are other provisions that you have to learn with regard to Article 25. I'll discuss that elaborately when I come to the elaborate discussion of Article 25. And apart from Article 25, if you see this particular part, that is the religious rights, also consist of Article 26, Article 27 and Article 28. Now what is Article 26 of the Constitution talks about? Article 26 of the Constitution talks about right that is guaranteed to religious denominations. So what is a religious denomination? In case if it is a religious denomination, the religious denomination exercise certain rights. And every religious denomination under Article 26 shall have the right to carry out religious activities and to engage in various other charitable activities and even to own and to manage properties. So these are all the rights that is guaranteed to a religious denomination, whereas Article 25 is for an individual as to what type of religious rights he can exercise, whereas Article 26 is for what is called as a religious denomination. And then Article 27 of the Constitution is talking about that the state shall not impose taxes in the name of religion. Or basically it is providing protection to the people that they shall not be imposed tax by the state in the name of religion. Or there can be no religious discrimination based on which the tax shall be imposed. So that is basically what is Article 27 of the Constitution, and then we'll move on to what is called as Article 28 of the Constitution, where we'll try to understand that where Article 28 restricts the state from imparting certain religious institutions in educational institutions. Of course, there are different types of educational institutions under Article 28, which we'll see in detail when I take up Article 28 of the Constitution. So this is basically what you are going to study under the religious rights, right from Article 25 to Article 28. So first we'll start with Article 25, which is the most important thing that you have to remember of all the rights. That doesn't mean that the other rights are not important, but Article 25 has a lot of things to discuss. So in this lecture, I'll focus my attention only on Article 25. And in the process of explaining Article 25, I'll also discuss as to what is Doctrine of Essentiality, and which is also a very important concept for the students preparing for UPSC examination. They should know as to what is Doctrine of Essentiality. So I'll discuss all those things as I'll proceed for the explanation of Article 25. So look into the title of Article 25. What does it say? Article 25 guarantees freedom of conscience and the freedom to profess, practice, and to propagate a religion of one's choice. So that means there are four important keywords that you'll have to understand as to what is this right to freedom of religion under Article 25. It gives us the freedom to conscience and also our freedom to profess, practice, and to propagate the religion of our choice. So what does it mean by conscience? Conscience is basically the inner self of an individual, or conscience is basically how an individual feels by himself. That means for an individual, as per his inner voice, he can decide what he wants to do. That is basically what is called as a conscience. So when you talk of right to freedom of conscience as a part of Article 25, it is strictly giving us an idea, or the Constituent Assembly wanted to make it very clear that religion is basically within the personal domain of an individual. Religion is basically a personal autonomy of an individual as to how he thinks about a particular religion, whether he believes in a particular religion, whether he doesn't believe in a particular religion, whether he believes in God or whether he doesn't believe in God, whether he wanted to establish certain type of relationship with a particular religion or not to establish a relationship with a particular religion. It is for the individual to decide, and the state has no business in this particular regard. That's basically what is called as freedom of conscience. So Article 25 is making it very clear the state shall not impose anything upon the citizens to follow a particular religion or not to follow a particular religion. It is basically for the individual to decide. It is your own conscience on which you can decide all those things. That's the first understanding you should have. Alright, so it's basically that it is up to the individual the way that they will mold their relationship with a particular religion, or they may not even have belief in any religion. That is for the individual to decide, because to that extent the right is guaranteed under Article 25 of the Constitution. So it is not only about the right to conscience or the freedom of conscience, but apart from that, we also have the right to what is called as right to profess, practice, and to propagate our religion. Suppose if you believe in certain things, which the state has no business whether you believe or you don't believe, but if you believe in certain religious practices, you have the right to openly declare your belief. You have the right to openly declare that what you believe, and whatever you believe, you can easily profess that also. That is what is right to what is called as profess. So you can declare your belief to others, which is guaranteed under Article 25. And you can also put that into practice in the form of various rituals, and that's basically what is called as right to practice. Say for example, different religion have their own religious practices. Hindu religion, they have their own religious practices. If you take Christianity, it has its own religious practices. Similarly, if you take Islam as a religion, it has own religious practices. And these practices are based on what is the belief and faith of an individual towards a particular religion. So when you go to any religious institutions or when you pray the God, probably the different religions have different religious practices. Say for example, when you go to Hindu religious temples, probably there is something which is called as puja, which is happening to the God. Or there's a system of what is called as arati, which is performed before the God. These are all practices based on their religious belief. So this is completely the right of an individual, which is guaranteed under Article 25 of the Constitution. So first of all, it guarantees what is called as right to profess, for you to openly declare your belief and faith about a particular religion, and then you can also practice it through various practices. You can also put it, and you can also have various rituals as a part of your religious practices. And it is not only about profess, practice, but you can also propagate the religion. That means you can propagate that whatever you believe to others as well, and you can openly profess that to others. And therefore, you can also spread your belief system to the others who are part of the society. And that's basically what is called as right to propagate as well. Now, these are all completely guaranteed under the Constitution. So, first of all, there is freedom of conscience. The state has nothing to do with whether you believe or not believe in a religion, how you believe in a particular religion. The state should be absolutely neutral in this particular regard. The state shall not force anyone to follow a particular religion. And apart from that, it is also the right of an individual to profess, practice, and to propagate a religion. But however, the most important thing when it comes to the religious right is, although there is something which is called as right to profess, practice, and to propagate a religion, that whatever you believe in, you can convey that to others also. Thereby, you can also enable the chances of spreading whatever you believe and the spread of that particular religion also. But does it mean that the right to freedom of religion under the Constitution of India is an absolute right? The right to freedom of religion, similar to that of the various other rights, is also not an absolute right. The right to freedom of religion can be restricted on number of grounds, and especially the grounds are given in the Constitution. So what are the grounds on which the right to freedom of religion can be restricted? It can be restricted on the grounds of public order. It can be restricted on the grounds of health. It can be restricted on the grounds of morality, and also on the grounds of violation of any of the other fundamental rights in Part 3 of the Constitution. Which means, on the one hand, that the Constitution is saying that there is freedom of conscience and the right to profess, practice, and to propagate a religion. But at the same time, whatever we profess, practice, or propagate in the name of religious rights shall not go against what is called as public order. That a religious practice should not threaten probably the peace and tranquility in the society. And in the name of religion, whatever practices we have shall not affect the health of the individuals. In the name of religion, we cannot do something that would go against the morality of the society. That is, the accepted societal norms are there. So it should not go against accepted societal norms. Or the religious practices shall also not be in violation of what is called as any of the other fundamental rights that is guaranteed in Part 3 of the Constitution. And if any of these things are likely to happen, then the state can impose certain restrictions on what is called as the right to freedom of religion. So definitely one thing that you have to keep in your mind is the right to freedom of religion is not absolute in character. So this is something that has to be very clear. And what is the ground on which it is subject to reasonable restrictions? On the grounds of public order, health, morality, and also on the provisions of violation of any of the other fundamental rights. Now, say for example, when I talk of public order, while Article 25 of the Constitution gives us the right to profess, practice, and to propagate the religion of our choice, and we also said that we have the right to profess, that the belief system is up to us, and then we can have our own rituals, and then we can also propagate that to others. Does it mean because we have the right to profess and to propagate the religion, does it also gives us a right to forcibly convert a person from one religion to another religion? So try to understand that while there is right to freedom of religion, which also gives us the right to profess, practice, and to propagate the religion, but that does not extend to forcibly convert a person from one religion to another religion. Because when you forcibly convert a person from one religion to another religion, then it goes against the conscience, freedom of conscience that is guaranteed under Article 25 of the Constitution. So that is not allowed. And that is not the only case. When you try to forcibly convert a person from one religion to another religion, it may have an impact upon the public order. And public order is a valid ground on which the right to freedom of religion can be restricted. So the Supreme Court has made it very clear. While there is right to freedom of religion, which allows you to profess, practice, and to propagate a religion of your choice, but it does not allow you to forcibly convert a person from one religion to another religion. Or nobody can use coercion or any of the other means to convert a person from one religion to another religion, especially the means like coercion, force, or fraud or inducement. These are all the mechanisms that should not be used to convert a person from one religion to another religion. If somebody is trying to use any of these means, then it may have an impact upon the public order, and that also goes against the right to conscience of an individual. And hence that is not authorized or that is not allowed under the Constitution. And to that extent, the state can restrict the forcible conversion of religion, because the right to freedom of religion is not an absolute right. It can be restricted on the grounds of what is called as public order. So the crux of the discussion that you have to remember right now is, while there is right to freedom of religion, But right to freedom of religion does not allow us to forcibly convert people from one religion to another religion, and that happens, then it can be restricted by the state. And many of the states or many of the state governments today have made a law in this particular regard to prevent conversion, that is forcible conversion. It doesn't mean that the religious conversion cannot happen. If at all the religious conversion is happening, the religious conversion has to happen by what? The religious conversion has to happen on the own conscience of an individual, by himself, and not by any of the means like what is called as force, fraud, inducement, or allurement. So these are all not acceptable. Force basically means coercion. Fraud means giving fraudulent information. So fraudulent information means people might be illiterate, and because people are illiterate, the religious conversion is much easier by giving them some false information. So that is also not acceptable. And then allurement or inducement means some monetary reward might be given for religious conversion. So that is again not based on the conscience of an individual. And hence all these things are not allowed. And to that extent, the state can restrict such type of religious conversion. But if an individual is voluntarily converting from one religion to another religion, that is out of his own conscience, and nobody can do anything about it, because that right is guaranteed to the individual. And similarly, the religious rights can also be restricted on the grounds of what is called as health. Now, say for example, suppose there is a religious gathering. People wanted to celebrate certain religion, but there is a pandemic that is there in the country. So, can the state impose some restrictions and say that the people should not gather at that point of time? So, because that religious gathering could also be part of their religious practice, because Article 25 allows them to do what? Right to profess, practice, and to propagate their religion. So, they wanted to perform certain rituals as a part of their religious belief. But at the same time, because there's a pandemic, can the state impose restrictions on the gatherings of the people, even if it is part of their religious rights? Yes, the state is allowed to do that in the interest of what is called as health. Similarly, if you look into during the COVID time, a lot of restrictions has been imposed on the various religious practices, especially people going to temples or any of the other religious places, having their religious practices was imposed, and certain element of restriction was done by the state, and that can be done in the interest of what is called as health. So you'll have to understand that while there is right to freedom of religion, but this right to freedom of religion is not absolute. And then it can also be restricted on the grounds of what is called as morality. So for this also I'll give an example. Say for example, there was a sect of monks under the Jain community who are called as Digambara sect. These Digambara monks, as per their religious belief, that they should not wear any dress, and they follow what is called as nudity. That is part of their religious belief. Let us not get into the religious belief. So they were practicing nudity, and that is when the state has imposed some restrictions upon them. The state said that if you are practicing nudity in public places, it goes against the morality of the society, and hence we may not allow you to perform this. So while the Constitution guarantees the right to freedom of religion, which includes the right to profess and practice, but it shall also not go against what is called as a public morality. And in case if it goes against a public morality, and to that extent it can be restricted by the state. So it is not only on these grounds, on the grounds of public order, health, or morality, it can also be restricted on the grounds of violation of any of the other fundamental rights. Now, say for example, now if any of the religious practices are violating any of the other fundamental rights, then also it can be restricted by the state. Now, say for example, untouchability was a practice within the Hindu religion. So it was accepted as a religious practice. But today, untouchability is a fundamental right, which is guaranteed, or it should be prohibited under Article 17 of the Constitution, because Article 17 of the Constitution talks about abolition of untouchability. So if any religious practice is following what is called as untouchability, the state cannot be a mute spectator to this particular religious practice just because Article 25 guarantees them what is called as right to freedom of religion. The state can impose restriction on this because the religious practices or the religious rights guaranteed under Article 25 shall also not be violative of any of the other fundamental rights. So this is the basic understanding you should have. So before I move forward, we should also understand a lot of other things under Article 25. So before I move forward, So first thing that you have to understand is Article 25 is more individualistic in character as to what are the rights, especially the religious rights an individual can exercise. It guarantees right to freedom of conscience and the right to profess, practice and propagate the religion of his choice. But however, this right is not an absolute right. And it is not an absolute right in the sense the right to freedom of religion guaranteed under Article 25 can be restricted on the grounds of public order, health, morality, and also on the grounds if any of the religious practices is violative of the other fundamental rights. And most importantly, you'll have to understand now, when we talk of the kind of religious rights, we should also understand the kind of secularism that is allowed in our country. And many times we might have heard that the kind of secularism that is followed in India is a little different from the kind of secularism that is followed in the Western countries. Is India a secular state? No doubt. The preamble declares India to be a secular state. And to that extent, we are also a secular state, which means the state treats all the religion equally. The state does not discriminate on the basis of religion, nor the state identify itself with any religion. But however, if you say India as a secular state, it is little different from the concept of Western secularism, because the kind of secularism that we call India is what is basically called as positive secularism. That is how we define secularism in India. Whereas the secularism in the Western countries, they are basically what is called as negative secularism. That is because of the fact that the state is completely separated from the religion, or the state institutions or the state does not interfere in the religious institutions or their affairs. But whereas in India that is not the case. In India, the religious intervention is possible. The state can intervene in the matters of religion, but it is a positive intervention, which we'll understand subsequently by reading what is given in Article 25 of the Constitution. So come to Article 25. If you further read Article 25 of the Constitution, Article 25 of the Constitution makes it very clear that the state can regulate or restrict the economic, financial, political, or the other secular activities associated in the name of religious practice or associated with religious practice. What does this mean? That means Article 25 of the Constitution on the one hand allows the right to profess, practice and propagate the religion of one's choice. It doesn't prohibit the state in intervening in various economic, financial, political or other secular activity associated with the religion. It is not saying that the state will associate with what is called as the religious activities, but it is saying that the other social, economic, financial, political or other secular activities associated with what is called as religion. Secular means which is basically not directly related to religion, but they are activities which is secular in character, which includes economic, financial, political and other secular activities. Say for example, suppose let us assume that there is a temple and there is a lot of donation that is received by that particular temple, aid that is received by that particular temple. These things can be managed by the state. It is nowhere related to the religious activities, but these are all associated with what is called as economic and the financial activities. Similarly, if anybody is using the religion to have political gains or polarize people on the basis of religion and thereby they are having political gains, these things may be restricted by the state by way of a law. For example, there is a law in our country which is called as the Representation of People Act, RPA 1951. As per the Representation of People Act 1951, use of religion to polarize people during election is a offence. It's considered to be an electoral offence. So all these things may be regulated by the state. And similarly, the state can also regulate any of the other secular activities. Say for example, the state can involve in management of various religious institutions or religious places. These are all associated with the secular practice, not associated with the religious practice. Now, there is a difference between religious practice and secular practice. Religious practice are associated strictly to the religious matters or the beliefs within the religion. But secular activities or peripheral activities, they are not directly related to the religion, but they may be some way connected to the religion, but they are secular in character. So this is basically what is called as the right that is given or the power that is given to the state to regulate the or to restrict the economic, political and other activities related to what is called as religion. That means basically you will have to understand on the one hand where there is right to freedom of religion, but on the other hand, the constitution also allows the state to intervene in the matters of religion. And what are the grounds on which they can intervene in the matters of religion? To regulate the economic, financial, political, or other secular activities associated with religion. So that is why we say that in India we follow a model what is called as positive secularism, as I already said, because positive secularism allows for what is called as interventionist approach. The state can intervene in the matters of religion, but not strictly in the religious matters, but other secular activities associated with religion. And apart from that, the most important thing is Article 25 of the Constitution also allows the state to intervene with regard to what is called as social welfare and reform within certain religion. Now, why this becomes very important is the members of the Constituent Assembly knew that very well a lot of religious practices in our country, they were not in line with the fundamental rights that is guaranteed in the Constitution. Say, for example, there are a lot of religious practices. When the Constitution was drafted, there are a lot of religious practices that was not in line with the fundamental rights. When I say that they are not in line with the fundamental rights, that many of the religious practices in different religions, they were going against the various fundamental rights. Say, for example, take the Hindu religion. Hindu religion had the practice of sati, although that was done away with, but still it was believed that sati is a well established practice within Hindu religion. Say, for example, untouchability. Say, for example, child marriage. Say, for example, gender discrimination within the religion. Say, for example, the practices like instant triple talaq in the Muslim religion, so on and so forth. A lot of practices were followed. In some of the religion, the women are not allowed to enter into the religious practices, which is part of the religious practice, and therefore it brought in what is called as gender disparity or gender inequality within a particular religion. So the Constituent Assembly very well knew that within every religion there are certain practices which is not in line with the fundamental rights, which is not in line with the principle of equality, which is not in line with the principle of social justice. And therefore, if any such practices are there, then it should also be possible for the state to regulate and to reform these things. And to that extent, the state is empowered under Article 25 of the Constitution. That is what they say. The state can provide for social welfare and reform, and therefore they can also throw open the Hindu religious institutions of public character to all classes or sections of Hindus. One thing it is saying that the state can bring in what is called as social reforms, especially when they feel that any of the religious practices are going against what is called as the rights of the people, or it is in a line, it is not in line with the principles of equality or social justice, then probably then the state can intervene in all those things. And similarly, they can also throw open Hindu religious institutions of public character. What do you understand by Hindu religious institutions of public character? So basically, temples that is belonging to Hindu religion. And public character means these are temples which are either managed by the state or there is a state funding to these temples. It's not talking about the private temples or the private properties. Hindu religious institutions of public character shall be thrown open to all sections of Hindus. This is basically, at that point of time, there was a lot of caste discrimination within Hindus. So in order to prevent that, so all sections of Hindus shall be allowed to enter into the Hindu religious institutions of public character. So that is also allowed under Article 25 of the Constitution, and to that extent the state can take measures. This is what basically we'll have to understand. But however, you'll have to keep in mind one small explanation is given under Article 25, which says, so here when you say the all Hindu institutions of public character, and it shall open these institutions to all classes of Hindus. So who are all considered to be Hindus as per this particular article? An explanation is given in the Constitution. Hindus would mean not only people belonging to Hindu religion, but also people belonging to Buddhists, Sikhs and the Jain community. So try to remember this. Who are all considered to be Hindus under Article 25? It is Hindus, Sikhs, Buddhists and Jains. And apart from that, one more explanation is also given, especially for the Sikh community, as to what would be considered to be part of their profession is carrying kripans. So you know that the Sikh community have certain religious practices, and one such practice is what is called as carrying kripans. So that is recognized in the constitution itself. It is part of the profession. It is part of the beliefs system of the Sikh community to carry what is called as kripan. So kripan is something like a sword that they carry, and it is part of their belief system, and that is recognized in the constitution itself. So this is basically what you'll have to understand under Article 25 of the Constitution. And that is why we say that the kind of secularism that is followed in India is what is called as positive secularism. It is not negative secularism. Is India a secular state? No doubt India is a secular state. But what type of secularism that we follow? We follow what is called as a positive secularism. That means on the one hand, the religious rights are given to the people, but at the same time, the state can make intervention in these things. But why they make an intervention? Positively they make an intervention, because some of the religious practices should not go against the rights of the people. Some of the religious rights should not discriminate people. Some of the religious practices should not go against the principle of equality, which was widely there at the commencement of the Constitution. And whenever the state sees such practices, the state cannot be a mute spectator to all these practices, and therefore the state has to intervene and bring in reforms. To that extent, it ensures equality among the people. And that is why such system of secularism is what is called as positive secularism. So this is the basic understanding you should have. But before I conclude Article 25 of the Constitution, now we are coming into an important discussion that religion is a very sensitive matter. On the one hand, Article 25 is saying that the people shall have the right to profess, practice, and propagate the religion of their choice. But on the other hand, it is also saying the state can intervene in the matters of religion. But religion is a very sensitive matter. If the religion is intervened by the state too much, then it becomes problematic, because religion is the heart of every sections of the people, and they feel that to be very sensitive. And to what extent? So to what extent, if at all, the state can intervene in the matters of religion, to what extent they can intervene? And this matter was taken up by the court, and the court has come out with a doctrine, which is what is called as Doctrine of Essentiality. So what is this Doctrine of Essentiality is trying to say is that whenever the state intervenes in the matters of religion, the state has to make sure that it intervenes not in the essentially religious practices, but rather it can intervene in the non-essentially religious practices. That means, in the opinion of the Supreme Court, when they innovated this particular Doctrine of Essentiality, they said that if you take any religion, in every religion, there are certain practices which are very core of the religion, and there are certain practices which are very peripheral to the religion. When I say religion which are core to the religion, without these practices, the religion cannot exist, or the practice of the religion is not possible. That belongs to the very core belief and faith of that particular religion. Those religious practices are what are called as essentially religious practices. But there are certain other religious practices which are surrounding the religion, probably peripheral to the religious practices. And if these religious practices are taken away, that will not affect the practice and the existence of the religion. So those are all called as non-essentially religious practices. So what the Supreme Court is trying to say is, the Supreme Court is trying to balance by innovating this particular Doctrine of Essentiality, wherein it says whenever the state has to intervene in the matters of religion, they'll have to see where they are intervening, whether they are intervening in the essentially religious practice or they are intervening in the non-essentially religious practice. So if they are intervening the essentially religious practice, due attention has to be given by the state. So normally they should not intervene in what is called as essentially religious practice. And where they can intervene is what is called as non-essentially religious practice. And that is basically what is called as Doctrine of Essentiality. So with that, now we'll enter into the next topic, that is Doctrine of Essentiality. I have given a basic introduction to this Doctrine of Essentiality, but the discussion is not yet over. So what did I say? This Doctrine of Essentiality is basically to balance between the right of the people when it comes to the religious rights, and to what extent the state can intervene in the matters of religion. Because as I already said, religion is very sensitive. Too much intervention will also create problems. So somewhere you'll have to balance between the religious rights and the authority of the state to intervene in the matters of religion. So the Supreme Court has innovated this particular Doctrine of Essentiality in a case which is called as a Shirur Mutt case. So you can see the name of this particular case, Shirur Mutt case in 1954. In the Shirur Mutt case in 1954, the Supreme Court came out with an idea of what is called as Doctrine of Essentiality. That means in every religion, there are two types of practices. One is there are essential practices to the religion and there are non-essential practices to the religion. Essential practices means without these practices, the religion cannot be practiced. The religion cannot sustain. They are part of the core belief of the religious system. Non-essential practices, without these practices, the religion can still be practiced. The religion can still exist and survive. These are all non-essential practices. So this doctrine is saying whenever the state is making an intervention, they can make intervention to the non-essential practices, but not to the essentially religious practice because it is at the core of the belief of the religion. So before the state makes an intervention, you see whether it is an essential or a non-essential practice, and who is supposed to determine as to what is an essential or a non-essential practice. It is for the judiciary to decide as to what is an essential or a non-essential practice. That is basically what is called as doctrine of essentiality. In fact, this has been applied in number of judgments. We will take few judgments for example. Say for example, the Sabrimala case 2018. I am sure most of you might be aware of this Sabrimala case 2018. If you see this Sabrimala temple case 2018, the major issue is whether the women in the age of 10 to 50 years shall be allowed to enter into the temple, into the main shrine of the temple Sabrimala. In fact, there was a religious belief that women in this age group shall not be allowed to enter into the temple, and that was also accepted not only as a norm but also accepted by the local laws. This happened in the state of Kerala. The Sabrimala temple is in the state of Kerala, so the women were not allowed to enter into the temple, especially the women in the age group of 10 to 50 years. And this practice was challenged in the court, and they said that women not allowed to enter into the temple is a violation of number of fundamental rights. It's violation of right to equality under Article 15. It is a discrimination on the basis of sex. It amounts to a practice of untouchability because it creates a social disability upon the women. So violation of Article 17. It's a violation of Article 25 of the Constitution because the women are not allowed to practice their belief because they may also believe in the God and they are not allowed to do the rituals and all those things. So it is violation of the right under Article 25. Now to that extent it was challenged. So a petition was filed and the petition challenged this particular practice of not allowing women in this particular age group into the temple. But whereas on the other hand, the temple management argued that no, it is an essentially religious practice within the Sabrimala temple or within the Ayyappa religion. In fact, they said Ayyappa is a different religious denomination within Hindu religion. So they argued that it is an essentially religious practice, so this practice should not be done away with. But however, the court was not convinced that it is an essentially religious practice because the court felt that if this practice is done away with, it is not having any existential threat to your religion. And hence this is not an essentially religious practice, and to that extent the Supreme Court said that this has to be done away with because it is basically in violation of the fundamental rights, and the religious rights that is guaranteed under Article 25 is not to take away the fundamental rights, the other fundamental rights that is guaranteed in the Constitution. And if the religious practices are violative of other fundamental rights, then state can make an intervention. And to that extent, the Supreme Court said that this practice of not allowing women in the age of 10 to 50 years should be done away with. Anyways, the judgment has been given, but the implementation has not been very effective. That's a different story. But this is what has happened in the Sabrimala case, where the Supreme Court has applied what is called as doctrine of essentiality. And similarly, I can give you one more example, what is called as instant triple talaq. Now, instant triple talaq is a practice within the Islam religion, wherein the husband can divorce the wife by saying what is called as talaq. And if the husband says talaq, talaq, talaq 3 times, and then there is a divorce between the husband and the wife. So this is one of the practice that is followed as per the Muslim religion. And this practice was challenged in the Supreme Court. And the Supreme Court said that we cannot accept this particular practice because that goes against the fundamental right of the women. While the men can do this, the women cannot do this. There is no equality. And if the woman is divorced by the process of talaq, then under the Muslim personal law, the woman is not also not getting any maintenance after divorce, and hence it may be violative of number of fundamental rights of the women. So we cannot allow this practice to exist, because this practice is violative of the fundamental rights that is guaranteed in the constitution. But however, the Muslim personal law board, along with the other people, they said that it is part of the religious practice. Then the Supreme Court said, okay, prove us this is part of your essentially religious practice. But however, ultimately, after all the arguments, the Supreme Court was not convinced it is not part of your essentially religious practice, and thereby we are declaring that this practice is unconstitutional. And to that extent, today a law has also been made by the state, by the parliament, to do away with the practice of what is called as instant triple talaq. So that means basically try to understand, wherever if there is any religious practice which is in violation of the fundamental right, the state intervention is allowed. But before making that intervention, the court is saying that see whether it is an essentially religious practice or non-essentially religious practice. If it is not an essentially religious practice, make the intervention. So that is not an issue. That is how this doctrine works. Similarly, in 2022, there was a hijab ban that was imposed in some of the schools in Karnataka, that inside the classroom, the orders as per the government said that Muslim girls who are going to the school, they should not wear what is called as hijab. And then later you can understand as to what is a hijab. Hijab is basically a headscarf that they wear. So this order said that inside the classroom premises, that the Muslim girls who are part of the education institutions, they should not be wearing the hijab. But then there was a resistance to this government order, and then it was challenged in the Karnataka High Court, telling that it is violative of the religious practices and the religious belief of the Muslim religion. And it is part of their belief system, and thereby they also practice that in the form of what is called as hijab. But however, the Karnataka High Court again was not convinced, because if there are different dress code, because in any governmental organization, in any school, there could be a dress code, and they can come out with a dress code, and if different people are having or not following the dress code, and that would amount to violation of what is called as a principle of equality. When somebody is following, somebody is not following, then that would amount to what is called as principle of equality. And hence, to that extent, we can regulate what is called as the religious practices, if in case if it is in violation of the rights. Now, to that extent, then this matter has gone to the Karnataka High Court. So the Karnataka High Court said, okay, prove that it is an essentially religious practice. Wearing hijab is an essentially religious practice. And subsequently, the Karnataka High Court was not convinced that hijab is an essentially religious practice. They said that we do see a same women wearing hijab at some point of time, not wearing hijab at some point of time. We do different women within the Muslim religion not wearing the hijab in the first place. So we don't see this to be an essentially religious practice. It may be part of your religion, but it is not an essentially religious practice. So the state can intervene in these areas. That is the judgment again that is given by the Karnataka High Court. So I'm not getting into the positives and negatives of this particular judgment, but I'm just stating what the judgment has been given by the court. So all the three examples we have seen that where certain practices has been declared as non-essential practices, and therefore the court allowed the state to make intervention in these areas. Similarly, I'll also give examples where the state has declared certain practices, the court has declared certain practices to be part of what is called as essential practices. Say for example, in the Commissioner of Police versus the Gurpreet Singh case in 2018, the Supreme Court declared that carrying kripan is part of an essentially religious practice of the Sikhs. Kripan is basically the sword that they carry. In fact, under the Sikh religion, they believe in 5 things. As a part of their profession, they believe in 5 things. And one important thing, that they have to carry 5 things as a person who is professing what is called as Sikh religion. And one among them is what is called as kripan. Kripan is basically the sword that they carry. So this case has made it very clear that carrying kripan is part of their profession, and it is also part of their practice, and it is part of their essentially religious practice. If you put restrictions upon carrying kripan, then it is going to have an impact on the very existence and practice of the Sikh religion, and hence that should not be touched upon. Okay. And then there was one case which is called as a Shirur case. In fact, this is the case where the doctrine of essentiality was brought in. If you see the Shirur case, in the Shirur case, the Supreme Court has said that there are certain rituals, say for example, doing puja within Hindu religion to the god, showing arati to the god. So these are all very much part of the essential religious practices within Hindu religion, and hence these things should be allowed to be continued. So to that extent, in certain cases, the Supreme Court has declared certain practices to be part of essentially religious practice and certain practices to be non-essentially religious practices. So the idea is that if they're essentially religious practices, probably the state should not intervene. That doesn't mean that the state should not intervene at all. Probably the state should avoid from making intervention in these areas. But if it is a non-essentially religious practices, and thereby if these practices goes against public order, health, morality, or on the violation of any of the other fundamental rights, the state can make an intervention, and that is basically what is this doctrine of essentiality. Very, very important for you to have an understanding. Now, the biggest criticism of this doctrine of essentiality is that who is determining what is essential and not non-essential as a part of a religion is the Supreme Court or the judiciary. Now, the critics say what expertise that the Supreme Court judges have in deciding certain practices to be part of essentially religious practice or non-essential as a part of religion. The critics say the judges may be experts in the matters of law, no doubt in that, but they may not be experts in the areas of what is called as religion, and hence it is beyond the domain of what is called as judiciary. So the judiciary should not involve in determining what is essential and what is non-essential. And in fact, if you see the lot of cases where the judiciary has declared certain practices to be non-essential practice or declared a practice to be an essential practice, they have not followed a unique methodology. In certain cases, they relied upon the religious text. In certain cases, they relied upon the oath that was given or the witness that was given by religious experts. In certain cases, they relied upon the empirical evidence, the behavior pattern of the people. So, in fact, they also did not follow one unique methodology. So, the critics say it should be completely outside the domain of the judiciary. The judiciary has no expertise in deciding as to what is essential and what is non-essential, but that is a critical aspect. But as of now, the Supreme Court has following this particular doctrine of what is called as doctrine of essentiality. And basically, doctrine of essentiality means every religion has certain practice which are very essential to the religion and certain practices which are non-essential to the religion. And whenever the state is making intervention, they can normally make intervention in those practices which are non-essential to the practice of religion, provided those practices are going against the public order, health, morality, or if those practices are in violation of the fundamental rights guaranteed in Part 3 of the Constitution. So, if you see the entire Article 25 of the Constitution, you will very well understand that on the one hand, Article 25 confers fundamental right upon the individuals, that is freedom of conscience and the right to profess, practice and to propagate the religion of their choice. On the other hand, it also allows the state to make interventions on the secular activities related to religion, that is the economic, the political and other secular activities. And also it allows the state to make reforms in religion, provided if the practices within the religion are violative of the fundamental rights. So Article 25 on the one hand gives the right to the people, on the other hand allows the state to intervene. And that's why the kind of secularism that we follow is what is called as positive secularism, that allows the state to make an intervention. If you see the Western countries, on the contrary, in the Western countries, especially in USA or in countries like France, the state do not make any intervention in the religious matters. Religion is a completely a personal affair. So that is why they are called as what is called as negative secularism. Anyways, the same cannot apply to India because the Constituent Assembly thought that there are a lot of religious practices within India which may go against the fundamental rights of the people, and therefore it is necessary for the state to make an intervention in the interest of ensuring equality, in the interest of ensuring what is called as gender justice. So this is basically what you'll have to understand with regard to what is called as the right to freedom of religion under Article 25 of the Constitution. So with that, we are coming to the discussion of end of Article 25. In the next lecture, I'll deal with Article 26, Article 27 and Article 28. I'll do that in the next lecture. But before I complete this lecture, so please come to this particular question. Consider the following statements. The right to freedom of religion can be restricted only on the grounds of public order, health and morality. So the word only is very important. See whether the statement is right or wrong. Statement 2. There is no way the state can intervene in the matters of religion under the Constitution of India. Can the state intervene in the matters of religion or not? That's a second question. That's a second statement. So which of the statements given above are incorrect? So out of the two statements, how many are incorrect? The options are 1 only, 2 only, both 1 and 2 only, and neither 1 nor 2. So you can put the answers in the comment box. Now with that, we are coming to the end of this particular discussion. And if you have any queries that is related to this particular topic that I have discussed, you can reach out to me through my Instagram account or through my Telegram channel, which is Babu, BABU _IAS _337. So with that, I'll wind up the session, and in the next lecture, I'll continue Article 26, Article 27 and Article 28. Before I wind up the lecture, a small request from my side. If you have any friends or family members preparing for the IAS examination or any of the other competitive examination, you can refer them this particular channel and this particular series, and I'm very sure it will be useful to all of them. Thank you very much for watching this particular lecture. Keep watching. All the best.